done a very good job of researching it, and Chairman Turner is going to have hearings this summer, and he's asked that everybody, whoever's got an issue or whoever has information on that, needs to bring it to him, because he's going to handle it from that standpoint. So I wanted to mention that before we got into that. So with that being done, our first one is going to be, and I'll call this one up, is our nominee, Mr. Buffington. Howard, thanks for coming. And you, in subcommittee, we did advance your nomination, and he is for the Mississippi Tort Claims Board as chairman, which is serving as the will and pleasure of the governor. So there is a recommendation from the subcommittee for advise and consent, but I wanted you to have a chance to address the committee, and certainly if any members have any questions that they can do that. So I'm going to turn it over to you.
Well, thank you, Mr. Chairman. I appreciate y'all having me today. I appreciate y'all considering my nomination. I'll tell you a little bit about myself. I'm from Canton, Mississippi. That's where I grew up. I graduated from University of Mississippi, like in the finance degree, went to Mississippi College School of Law, and I've been practicing for about 38 years. No, I don't put that on, but I've been practicing about 38 years. My general practice is advising boards of directors on a wide variety of issues, including litigation issues. I also do some commercial litigation, and I've handled class action lawsuits. So I feel like my experience is there to fill this role. And that's really all I have to say about myself, other than the fact that I am active in the community. I'm active with the Madison County Business League Foundation, the American Heart Association, Habitat, and several other organizations. But I appreciate y'all considering me, and I'm glad to answer it.
I'll ask the one catch-all. There's nothing you know of that would be embarrassing to the governor or to the committee if that should come out.
No, sir, there's not. I told Senator Boyd that I'm relatively dual person.
That's good. Any questions for our nominee? Anybody want to speak in his behalf? Senator Boyd.
I'll just say I looked into him, and he's a great candidate. We appreciate his service and the service that he'll provide to the state. So the commission would be to advise.
The motion is advise and consent. All in favor, say aye. Aye. Opposed? Congratulations. That'll go to the full floor. Thank you for coming. Appreciate it. Thank you. All right, we will go on. I'm going to go to the ad hoc subcommittee. Senator Boyd, House Bill 590.
Process would be with this as the chair of the organization, professional fundraiser, fundraising council, professional services, contributions to the state should be subject to an expert demand as provided for in this section, and shall be subject to service process as provided by the procedure. That is Representative Cochran Young's vehicle.
Any questions? Motion.
Title sufficient to pass.
Motion title sufficient to pass. All in favor, say aye. All opposed? Motion carries. All right. House Bill 961.
House Bill 961, as I last said, this is my counterpart from Oxford. This bill is also, the Senate has already seen this. We had a similar bill from Chairman Parkins. It's the exact same language that we had in this bill. What it does is, as I said, very much affects that community. We have robots that are going around, we first in the city quite readily, and when it does, it Starship robot, we have at the University of Mississippi. Starship like has a cargo bay that's locked and open by the recipient on the cargo bay. So that's how it kind of works in that area. So we know that Amazon and FedEx are using this to customer doors, curbs, traveling the sidewalk, as well as climbing steps. Southern states, such as Tennessee, Louisiana, and Georgia, have passed legislation so that these devices can be used. This legislation here today would allow it to go forward in Mississippi in the same manner that happens in other states. In addition to the described in this bill.
Any questions? Have a motion?
Title sufficient to pass.
Motion is title sufficient to pass. All in favor, say aye. All opposed? Ayes have it. That carries. All right, next one, House Bill 1367.
Yes. This bill was brought to us in a situation that I did not know, quite frankly, existed by Representative here today.
I said we would handle it.
Okay. I did not realize that we have something was needing not a property attorney, but we have in our property descriptions, if you're in certain language, basically doing a closing or a couple to summer black couple and language that is contained in those prior names and very discriminatory language in it. And so we know that language is illegal, but he did some research and looked at some other states and brought forth the bill. And this is amended from the House version. It's what we looked at in the subcommittee and had no issues with the House. I heard it go straight. And this is a process that doesn't allow us to make sure that there's an easy procedure of clearing up those particular issues when they come forward. That would not be at a huge expense to the individuals. So that is kind of a brief discussion of the bill. Additionally, in this piece of legislation too, there was some language that was in some property, if you look at section 6, there was some language in a bill that had to do with grade clubs, institution of higher learning, and so we're cleaning up all that language as well. So that is an explanation of the bill. And
Any questions? Senator Hobson.
Thank you, Mr. Chairman. I want to determine whether or not the language is discriminatory. Is this subjective or objective? The only categories: race, color, national origin. Is that right?
to my understanding, yes, Senator Hobson.
And Senator Hobson, in subcommittee, when Representative Owen was explained it, if I'm remembering right, he said the U.S. Supreme Court has ruled such language unconstitutional. And when they found this, it was still there, and that's why we're trying to clean this up. That's what his bill is doing, is to remove that out of the code.
Okay. I've dealt with this before, and my opinion that I gave at the time was that the language was discriminatory, therefore constitutional, and you can based on the law of the land. And so my opinion at the time was that you can disregard language based on this. I wonder if the petition is even necessary. I'm getting to this. Is the petition process in reference to even necessary? And does that create an extra expense for someone? And they can look at the language that's clear on its face and say that's a Supreme Court language.
I would say that somebody in subcommittee chair could refresh my memory, but I remember that being brought up in subcommittee. And as he explained it, the clients, those in particular, they wanted it to be the law to be changed. Because that was the advice that was given, and for certainly human purposes and legal purposes, he presented to the committee that it was, that's why we wanted to go.
Yeah, Senator Hobson, he had, as the
right, it's,
teases out, if I'm a first time, if I'm a home buyer period, and then we're first time that, there's no covenant on the land, there's some restriction in private deed that is discriminatory in its nature, then I'm gonna have to go file a petition for, the cost to me there to move forward, give the deed, give the property rent. Is that correct? And if I don't file a petition, what happens?
Yeah, it is, this is.
So this is just a, if you wanna do it, you can, if you don't wanna do it, you don't have to.
It might particularly change Representative Evans' case, his plan, that, yeah.
any other questions? Senator McCon?
Just for clarification, Senator Boyd, I know you worked on this bill through it, and you and I spoke on this bill earlier, as did Representative Owen. One thing that was a concern to some of the clerks is, if there is a petition filed, this does not prohibit, the filing fees, the charging of a filing fee, or the indexing fee for a clerk to the land records, correct?
Correct.
Thank you.
Any other questions? Right, have a motion.
Title sufficient to pass any sub. Yes.
Motion is title sufficient to pass committee sub as amended. All in favor, say aye. All opposed? Okay, that carries. Thank you, Senator Boyd. Appreciate that. All right, we'll go to, civil law procedure, Senator McCon, and call on House Bill number 172.
Thank you, Mr. Chairman. This bill is very similar with the bill that we passed out of our chamber earlier. This is the Mississippi Architects and Engineers Good Samaritan Act, 172 there. And what it basically does is whenever you've got a, basically a natural disaster in which an engineer or architect comes in and determines the strength and durability of the building, they come in that emergency time, they're allowed to have well, they've got a little layer of protection because they may come in that natural disaster time period and they're not going to be able to do a full assessment. So they come in there and they give an assessment, says we believe that it is good and durable for you to go in and actually start retrieving goods, whatever it may be. This provides a layer of protection in those emergency situations. That's all this bill is doing here. I'll entertain any questions, Mr. Chair.
All right, any other questions? Any questions? All right, have a motion.
Title sufficient to pass.
Motion is title sufficient to pass. All in favor, say aye.
All right.
All opposed? Thank you. All right, we'll go to House Bill 1105.
All right, Mr. Chairman, this is a bill that we've already had come through this committee one other time. It was amended just as it was when it first came to the subcommittee. You'll see the original language there, and you'll see our proposed committee sub there. Committee sub basically allows, it puts another section in there. You had subsection 1, but now you're going to have subsection 2, which says a notarial officer may charge a fee in an amount not to exceed $15 for services rendered for electronically unless otherwise prohibited by law or by rules promulgated by the Secretary of State. And what this is, it's basically allowing up to $15 charge for electronic note. That's exactly the same language we put in the last bill, and we're proposing that to go forward in this committee now. So I'll entertain questions on that one as well, Mr. Chairman.
Any questions? All right, do I have a
Title
motion?
sufficient to pass committee sub.
Title sufficient to pass. All in favor, say aye.
All right.
All opposed? Okay, that carries. Thank you. All right, I'm going to call up House Bill 1469. For the benefit of the committee, I will note that this has not come to the full committee with the recommendation of passage, but we do have Bill's author here, Representative Lane, who will present child conceived by assisted reproduction after the decedent's death. So, Representative McLean, all yours.
Thank you, Mr. Chair, and thank you to Subcommittee Chairperson for allowing me to come today. This bill would allow for a child who's born through assisted reproduction technology, such as IVF, to be able to inherit from a deceased parent. We don't have that in the books. We have about 24 states that have enacted this statute, which would allow for a child who's conceived after the death of a parent, and they would be able to inherit under intestate laws, and also be able to inherit through ancillary benefits, such as Social Security benefits and that type of benefit. Just to give you an idea of the states that have enacted this statute, we have Alabama, Arkansas, California, Colorado, Connecticut, Delaware, Florida, Illinois, Iowa, Louisiana, Maine, Maryland, New Hampshire, New Mexico, New York, North Dakota, Oregon, Texas, Utah, Vermont, Virginia, Washington, and Wyoming. So we have those states that have allowed that. We also have 6 other states that have answered that decision through court decisions. So I have a constituent in my district that she and her husband ended up going through IVF. He was diagnosed with cancer. He decided before his chemotherapy treatments that they would go and bank his sperm so they can have children after his treatments were over. Unfortunately, he passed away. So she decided to have a child through IVF and use their embryos. After the child was born, she realized that the child is actually not considered a child. The child is not considered a biological child of her husband simply because the child was conceived after his death. So with respect to intestate laws, with respect to estate and heirship laws, with respect to Social Security, that child is not considered an issue. So in order to make this right, I've proposed this statute, and we put in a lot of protections. We do understand that most states have put restrictions in the law that concerns closing an estate. We know that it could take 9 months, 10 months, 2 years to close an estate. So in this statute, we've proposed that there has to be a notice to the personal representative. So if you'll notice, on lines 43 through 46, we made sure that the decedent's personal representative, no later than 6 months after the decedent's death, has received notice or actual knowledge of an intent to use the genetic material. So that protection is there, because that's one of the main, I believe, oppositions is that, you know, we have an estate proceeding. We don't know if there will be additional heirs, but normally the personal representative in this type of case would be the surviving spouse. So the spouse would actually know. So we've taken care of that. And then we also want to make sure that the decedent consented to this. So we also make sure, that's on line 51 through 56, that there's a written document by the decedent where he is actually, or she, it could be, wish to start a pregnancy by assisted reproduction technology. So, and then as you see on down 57 through 61, we have a rebuttable presumption that if the couple was divorced or legally separated, or that we would have a presumption that the decedent would not wish to move forward with this. Also, just to let you know that we have some uniform codes and uniform model laws that have actually approved this. We have in 2008, the Uniform Probate Code provided for posthumously conceived children, and that there's an assumption that all such children would be able to inherit from their deceased parent. We also have in the Uniform Parentage Act, we propose that in that act, a spouse who consented in writing would be a parent of a posthumously conceived child. So although Mississippi has not adopted the UPC nor the Uniform Parentage Act, we do have those types of model language around the country. And I would just urge that let's try to keep up with reproductive technology and make sure that our laws are up to date and keep up with the strides that we're having in technology and science. Thank you.
Okay, questions from the committee?
I've got a few, Mr. Chairman.
Senator Cotton.
And thank you for coming to explain this, Representative Goff. I do have a couple questions that concern me within the bill, and I'm the reason for that. I'm the subcommittee chairman. I'll take the credit for saying maybe we need to look at this a little bit further before we pass it. I have no problem with someone that at the end of the day has had trouble with it. It's more prevalent now than ever before across our society. But I do have some procedural questions before we even get into the larger picture here. I see in line 42, you mentioned the decedent's personal representative. And I find that often in my practice, an individual comes in and says, the bank wants my personal representative to sign off on this. But unfortunately, until we open the estate, we don't have a personal representative, correct? So we're going to have to open an estate to get a personal representative. Is that where we're at with this?
I'm really not sure about that.
Okay. Well, that's generally what's going to happen. Have an administrator or an executive. That executive will be appointed.
Right.
That's when the personal representative will come into play. So we definitely would have to have an estate to have a personal representative to be served upon the notice.
Okay.
That
Couldn't it be
appears to
someone that, so here we're talking about intestate, which that means without a will.
Absolutely.
So,
that'd be the administrator of the
right.
estate.
So maybe we could amend the language to, in that specific phrase there with
And that may
respect
be
to
something
that.
to look at.
Right.
And as we get further into this, the additional questions I've got here, we
Mhm.
might look at that further. The next question I ask is that we have a provision in here for a written, hey, I want to have a baby after you passed away.
Right.
So, is there a form for this document, or, I mean, you don't necessarily know, and I would take it at the end of the day, the individual may have already
Well,
discussed that with their spouse. In your situation, it's totally different, cancer's a vicious monster, and at the end of the day, he may want to continue with his offspring. So my question there is, do we have something to allow that out there?
well, actually, when you work with a fertility clinic, there are lots of forms that you have to fill out, and there is a document that you would have to sign in order to release any type of genetic material, whether that be an embryo, an ovum, an egg, a sperm, whatever it might be. So yes, there are, that's just part of reproductive technology, and I think that the clinics there have that in place. That would be something else that if we wanted to be more specific, I know that in some states, they say even it could be oral, here we've made it much more restrictive where it has to be written. And then in some states, they don't even require, they assume that if the couple was married, that they would agree to that. I mean, if you take an affirmative step of going to actually bank your genetic material, I mean, there's a presumption there that you intend to use that in some way or form in the future. So to me, it's almost like an assumption there, but we've made it more restrictive to have it written.
You mentioned there's an assumption out there. How long is a viable embryo going to stay in storage?
Well, they have said that it can be years. I mean, as much as technology and science advances, it can be longer and longer. I was reading the other day, it had been 28 years in one instance where something had been frozen. I believe that was sperm. But with eggs and embryos, it can be longer and longer as science and technology proceeds.
The other question I've got on the semantics here would be on line 58, legally separated. In our state, we have a presumption that marriage is in favor of being married and not to be separated. So we don't have a legal separation there.
Right.
So I don't know if that would be pertinent to our state. I understand there are other states that have language at the end of the day. They're not always right.
Right, exactly. And I believe that language was taken, where other states do have an actual legal separation status. But that could also be or no longer habitating together, or not necessarily legally separated, but separated and not cohabitating. But I would certainly be willing to work on some of those concerns and
And
language.
we absolutely will get to that here in just a moment. My last question is this. What would prohibit the individual from petitioning the Chancery Court in its utmost discretion and equity to declare the child a offspring of the individual? Because I know for a fact there's been instances where there's been posthumous DNA pool
Right.
to determine the paternity, and that's been done. So tell me why can't you just go ahead and petition the court in equity?
Well, that could be a possibility. However, I think the federal laws look to our intestate statutes to determine who is actually a child of a decedent. So we couldn't, it just makes it much easier and cleaner and simpler if we actually have it on our statute in our books. So I would think maybe they could, but I don't think that person would also be able to receive benefits for that child that the decedent had paid into. And that child deserves it. But also,
I disagree on that.
Right.
I'm just asking though, that if an individual, if my wife and I got pregnant and I was killed tomorrow, and or say we were not married and I'd gotten killed after getting someone pregnant or planning that together, and we were not married, there's still a requirement for them to go to Chancery Court and petition for that paternity to be put on that birth certificate. So I guess that's where I'm lost and holding kind of sitting on this side of the general practice. And that's the question I've got. I appreciate you answering those.
Sure.
Those are just my questions.
yes, absolutely. And I believe here we're talking about married individuals. And so that brings up a whole other set of issues as well.
Senator Hobson.
Thank you, Mr. Chairman. Thank you, Representative. It sounds like this may be something that needs to go to conference based on the questions that have been asked, and I think some changes to the bill, but let me just make a statement to the question. Some states close prior to 6 months is rare, but you have some that can go quickly. So I think you got a gap and a problem there, so you make it the state close, that needs to be worked out. I think also the question between the notification period and the in-utero is also concerned. I don't know that unless you get a determination by the court that they're opposed to that could die in the womb or something like that. So you got issues there that need to be ironed out. And I think the final thing that I see is I don't know in 45 months you might in utero at 36 because you could have delayed pregnancy or something. Like need to tweak that a little bit, but rather than me asking several questions, I would recommend that work would be added to this if it's not already. And this would need to see a little bit more.
Any other questions on the bill? Okay, amendment. So the amendment, now's the time. Amendment is a reverse repealer from Senator Hobson. Okay, all in favor of the amendment, say aye. Aye. All opposed? Okay, the amendment carries. Okay, we're back on the bill as amended. Do you have any questions on the bill? Senator McCon, we have a motion.
I think Hobson would be the better one there, Mr. Chairman.
We have, okay, is there a motion for universal drug ban? Okay, so it's title sufficient to pass, strike all as amended. All in favor, say aye. Aye. All opposed? Okay, the motion carries. Thank you, Representative. But I think to Senator Hobson's point, we got the reverse repeal, but it does sound like there needs to be some work on this. So that'll force it to committee, to conference. But our practice is if you're likely is subcommittee chairman's gonna be on the conference. Thank you. Appreciate it. Okay, next, thank you. We will go to House Bill 770. You have, this is the equal pay, what we have before you. Excuse me. You recall on the floor, we did a reverse repealer. On the equal pay, we did that. What you have before you is the House bill with our proposed committee substitute. And it's simply a strike all, putting our language into the House bill. Now, what we also have in the strike all, and so by the way, what I just mentioned, that section 1, section 2, section 3 is our irretrievably broken divorce bills. So, any questions? Senator Turner, for thank you. At this stage of the game, the House has chosen to decide that marriages, people stuck in marriages that are abusive and things like that is not that important. So this bill that's why this has been added. Also, equal pay is for the first time in, I guess really, anybody can remember, both chambers have an equal pay bill. So that's why. Senator Boyd. Okay, motion. Yeah, I'm sorry. Any other questions? Okay, motion.
Title sufficient to pass committee's substitute as amended.
Okay, you heard the motion. All in favor, say aye. All opposed? Okay. The motion carries. Thank you. House Bill 1061, which is the Residential Landlord Tenant Act. So what we have done, I will say this to the committee. If you recall, we had two residential landlord tenant acts, and what I would call the skinny bill, okay? And then we had Senator Johnson's, which is a comprehensive bill. The House and the Senate skinny bills were the same. If I believe and trust what the House is going to do, then they actually take that up and pass it. What the strike all before you is their skinny bill, and our strike all is the omnibus bill with the reverse repealer in it, so that this will go on. I have talked to Representative Cockerham. She certainly understands the comprehensiveness, and so this will allow us to continue with that discussion. It does have the reverse repealer. Open it up to any questions. All right, do I have a motion? Motion title sufficient to pass. All in favor, say aye. All opposed, motion carries. I'm sorry, strike all. If I don't say it, assume it. All right, House Bill 1067. That is child support provide orientation guidelines. Okay, this bill actually has come to us from the task force that we talked about. There were some agreements between the House and the Senate that there would be a House bill and a Senate bill. We would divide them up. This is one of those. The task force that we've heard about had made this recommendation. If you look at lines 74 to 86, that is the optimum language. The bottom line is this is in the task force, and it's in the report that when they looked at it and talked about the child support, there's a whole analysis that task force believed that that there were other issues that needed to be looked at, particularly on behalf of the non-custodial parent. And so if you look at line 75, it talks about that, in the absence of specific sufficient evidence of past earnings and employment history, that look at the recommended child support obligation amount should be based on available information about the specific circumstances of the obligated parent. This can include, but is not limited to, and it goes on about that. So the bottom line is this, is that when the chancellors are looking at the computation for child support, that they go beyond, in addition to just the stated guidelines, which by the way are current law in lines 12 through 18, that they can look at these other factors of the obligated parent to see if that is, I guess, equitable for the child. And that is what the bill does. Any questions on that? All right, do I have a motion? Motion is title sufficient to pass. All in favor, say aye. All opposed? That motion carries. All right, next, this comes to us from Highways and Transportation, House Bill 971. Senator Branning, would you like to explain that? You don't have to. Go ahead. Hey,
This particular bill, House Bill 971, it just increases the time period in which expired driver's license may be renewed without examination. I believe it increases from, I don't have my notes from current law. It's 18 months up to now 60 months is what it's still called. And then it has a digital wallet, language, which is the last part of the bill, section 2, beginning on line 50. And it allows the Department of Public Safety to be the state agency responsible for regulating digital wallet for state agency individuals. From what I understand, Commissioner Tyndall, people in Mississippi, like licensed real estate agents, and other professionals that hold a Mississippi commission license will be able to hold these licenses in the digital wallet, but it will be administered through GPS. So those are the two items addressed by the bill, and I'll be glad to answer any questions.
all right, thank you. Any questions? Have a motion? Motion is title sufficient to pass. All in favor, say aye. Next is House Bill 1069, and I am going to turn that over to Senator.
Thank you. This bill is before us.
I will note it has reverse repeal.
And what we're asking you is to continue to let us work on this, work with, and I appreciate the individuals in here, tax collectors, assessors who work, chiefs reports, everybody that's gonna work to try to see if we can get a reasonable solution to this. I have a letter here from the Land and Title Association of Mississippi. This bill, tried to do it last year to sort of address this situation. We've been working this year to try to address this particular situation. Just what it does is there have been serious problems for closing attorneys, title examiners, abstract members, those that are just conducting general title searches, and consumers and home buyers, because of the non-reported solid waste liens, the garbage liens that are handled differently and inconsistently across the state. This is a particular situation that it is handled vastly different in each particular county, and the law will allow for them to do that. Whichever situation that works best for those particular counties. And so the problem is that the liens are not reported particularly, so that title abstracts individuals can go search for these liens. In my community, we have a tremendous amount of property that is transferred back and forth on this. And it's a problem across the state. I've got an article that where it is from Tittawampah County, where they're having the same particular issue. And so what happens is that there will be garbage fee that is owed. And what has happened in my particular area is that garbage
still not being collected out there. So you will see additional future bills on this, but for this bill only, what we've done is, and what this is, bill from the House does is, all it seeks to do, if we look at lines 41, is to make sure that these liens are filed in the Judiciary Clerk's office in a separate hard copy and or digital format, so whichever format they use in that area. And they include the information determined to be needed for the recording and the indexing of the lien, and such information shall be in the clerk's office. And I believe we have an amendment to this.
Actually, already in the strike all, but, and I was mistaken, it did not, the strike all does not have a commercial fee.
Okay.
That was my bad.
Okay.
I need to address it.
Okay. So anyway, so that's kind of the actual understanding of the bill. It's just not encompass all the other issues that we know have come up with this. This simply, what this does is, which is the major problem that the title attorney and abstractors are having, is it does place it, put it in every user clerk's office, a place that needs to be filed and do proper search. It protects members from, like in my situation, going back and they think they pay their fees and everything, but no, prior owners, and then having to surprise them, finding out there's multiple parties. Fees that are owed on this property. So that's what it does. It's under a fund that we're doing this for long term as well.
Yeah, okay, so any questions?
Mr. Chairman,
Senator Simmons?
Yeah, thank you, Mr. Chairman. I remember a bill that came through municipalities that dealt with this, and I think it was one of the sub meetings. Is this the same bill that had it?
this is not, Chairman.
Not that I recall.
Yes, sir.
Would it address some of the concerns that some people have talked about?
Yes. This bill does, that you get, but liens are submitted here. You go to purchaser, they go to certify that the title is correct, there's no defect, this new place that you can go. These are new. We have not addressed all those particular issues that are presented. This simply is this is a notice bill, get on where these are new.
And the chairman said the reverse pillar is not in the bill. Would that be a friendly amendment? That'd be my amendment.
Senator McConnell.
Thank you, Mr. Chairman. There's, and Senator Boyd may shoot me whenever I say this, because I should have already thought of this. There has been a movement in the recent years to put this type of notice in the tax assessor's office, tax collector's office. And I wonder if we should not just put in here, shall be contained in the Chancery Clerk's office or tax assessor's office as designated by the Board of Supervisors. Senator Branning, is it tax assessor's office in Neshoba County, or is it in a separate office by itself?
It's gonna be in the tax assessor's office, and my suggestion would be, let's make it uniform on all the counties, because like many of you, we do work in multiple counties, and if we're out of our comfort zone, so to speak, working in another county, it'd be very easy to miss something if we're not working out of the same office for the liens. I would also suggest, should we, or this is more of a question, should we address statute of limitations on the liens? I'm not sure how that's gonna, once we establish a reporting system for this, just like we do deeds of trust, other liens in the Chancery Clerk's office, once those reportings are made public record, the statute tolls at that point in many instances. And I would just, as we're working on this, let's look at that issue. I didn't think of that earlier today when you brought it to my attention, but this is a good bill. We definitely, this is a good starting point. I support what you're doing here. We need it.
I guess my response, I'm sorry, my concern and the reason I even brought that up is there's been such a movement to go to the tax assessor's office because they can get rid of their solid waste office, put it in the tax assessor's office for that individual. But it may be we still have adequate time with Senator Simmons's reverse pillar request that we can get that work through.
I would say, Mr. Chairman, if we're trying to decide maybe the best location, certainly I want to continue the conversation with the clerks, with the Tax Assessors Association. We want to involve them, because at the end of the day, it's going to be their call upon them to make sure these records are kept, accurately. I know they're capable of doing it, but let's put it in the best place for user-friendly for those of us that do the abstracting.
So the motion is a reverse repealer into the strike all that we had. That's the motion. So all in favor, say aye.
Aye.
All opposed, motion carries. Okay, back on the bill, Senator Turner.
Should be assessed only in certain rare environments. And it's the owner of the property. Exactly. It's the market advertising.
Senator, it has been a point of contention among entitled attorneys. And unfortunately, when, say Senator Branning runs hers and her position is personal, and I run mine and I say it attaches to the land, get into theoretical arguments between title attorneys then. So that may be something we do need to clear
That's
up
a
there as
scintillating
well.
argument, by the way.
It's actually not proud.
I would argue.
I would say this, I think that's why you're seeing this debate. I think that's why this bill is here.
Should actually be stated in bold.
Well, let me say this, we have a reverse repealer in it, just like the previous bill. Clearly, there's work that needs to be done. For the record, this isn't a problem that I know of in Jackson or Harrison County, so. And you won't catch me doing title work, so, I think that needs to be worked. But we have the reverse repealer in it, and so I think that can be worked out. Okay, all in favor of the bill as amended, say aye.
Aye.
All opposed? Okay, that carries. Thank you. All right, last subcommittee, criminal law procedure, House Bill 698, mental health, Rivers McGraw mental health conversion project. Senator Egan.
Thank you, Mr. Chairman. This is actually a very simple bill. You'll see where this is now called the Rivers McGraw Mental Health Treatment Court Act. You'll see that throughout. It is no longer just a court act, it's Treatment Court Act. That's your section 1. You also see that we have under section 2, we listed legislative intent. A lot of this has not changed, although you will see the word treatment enter before court on a lot of these. But just to read specifically for you, it's the intent of the legislature to facilitate local mental health treatment court alternatives adaptable to Chancery Circuit, County, and youth courts. That's your section 2. Section 3 provides you with definitions found under the act. There are a lot of definitions, as all of our bills do. We like to define what we need to define in the bill. Section 4, which is really kind of the meat of the bill here, what this does is establishes criteria and standards to be established by the Administrative Office of Courts when it comes to these mental health treatment courts. So you have the Administrative Office of Courts that will go through and make sure that these standards are included in each of those so that you don't have a court just calling something a mental health treatment court. It'll actually be a court defined as defined under the statute here. And there is a data collection requirement for these courts to report back to the administration of courts, Administrative Office of Courts. I'm sorry, I'll get that correct here in a minute. AOC, we'll call it, just to save me some trouble. They will have to report back to those, and there is a recertification process. This is to make sure that we have accountability and transparency within the mental health treatment courts, and that they are, again, following their standards, that they're serving their purpose, they're helping. And when I talked with Representative Reynolds, who introduced this bill over in the House and passed it through, that was a big part he stressed. He thinks these courts are very helpful as long as we make sure that they're being run properly, and that and we do give instruction to AOC to do that. The compensation of the employees in the mental health treatment courts is also to be promulgated by the AOC. So if you have someone that's working with one of these courts in a county that may have these, and not all of them have them, this is just for those that do apply for them, you may have an individual, being paid a six-figure salary when they shouldn't be, and I guess the same would go the other way if that were the case. So it allows the AOC to look at that as well. Section 5 talks about the services that are to be provided by the courts. A lot of that section is already in law. You'll see a few sections where we've just clarified the definitions. Again, you'll see treatment court added. And I think that's important because the purpose of these courts is to provide treatment where necessary as an alternative to incarceration when eligible. Speaking of eligibility, Section 6 discusses those who are eligible for participation. When we had this in our subcommittee, the reason you have a strike-all before you, Senator Simmons and I discussed, and our subcommittee discussed in great detail, whether we needed to delineate the definition of what is classified as a violent crime when we already have a statute that does that. And Senator Simmons, I believe we went through and addressed that concern with this strike-all by just referencing the statute. And I would say that the also eligible are those who have committed a crime of burglary of an unoccupied dwelling, which we, and after speaking with Representative Reynolds, I believe that's something they wanted to make sure to keep in there because they do see individuals that can use this type of assistance from a mental health treatment court, and that's one of the crimes that maybe comes up a lot. So that's a way to help folks out where we can. Section 7, what that does is just ensures that the standards and the criteria that we outline in the previous sections are followed. Again, it gives the AOC that authority. It also gives the AOC authority to revoke certifications from mental health courts that are not following these standards that we outline here. Section 8, again, you just see we correct mental health court. It's mental health treatment court. You just see that throughout. This does provide a provision for drug tests of individuals that are involved in mental health treatment courts when those can be paid for by the individual. In other words, if the individual is not an indigent or if there's not a drug testing facility on location, those fees are to be paid by the participant in the program. We have more clarification of definitions under Section 9. Again, mental health treatment court coordinator. Section 10 allows for an expungement when the treatment court program has been completed. If the person completes all the requirements that have put on there, the participant, I should say, completes all the requirements, then that crime that led to them landing in the treatment court will be expunged, or it says dismissed here. Expungements under any other section, the requirements for expungements under other sections are not applicable here. This does expunge individuals that have completed the mental health treatment court, which is really an incentive to get folks into that and to help them move through and to encourage them to complete the programs. Same goes for if it's a civil case. If someone has been, if there's been a petition for commitment, that will be dismissed once a person completes the requirements under the treatment court. We do have a reverse repealer in this bill. I'm not sure if the reverse repealer is needed any longer, and I think that our chairman alluded to the fact that some of these bills are starting to get into our system and get into the political wheel. I wonder if maybe we could take out the reverse repealer and just send this bill over to the House as with a few amendments that we've made and see if they would like to pass it on and get it to the governor. Okay, well, I will make that motion now to remove the reverse repealer from our strike all and just have it stand in effect and be enforced from and after July 1st of 2022. So that's an amendment to the strike all. I'd like to make that before entertaining any questions on the bill. But
All in favor, say aye.
Aye.
Opposed? Carries.
Okay.
All right, now we're back on it.
Yeah, if there are any questions, I'm happy to entertain those at this time.
Thank you for your work on this bill. I think this is a really good bill. Can you tell me, the crimes that make someone ineligible for participation in the program versus the crimes that are eligible to be expunged under Mississippi law? In other just trying to determine if someone enters this program, their crime are we allowing for additional crimes to be expunged by someone entering this program that they otherwise would not be eligible? And I'm sorry, that's probably a terrible way to ask the question, but do you understand sort of where I'm going?
The only way it would be a terrible question is if I can't answer it. I'm not sure I can, but I'll try. No, Senator Brandon, I think that's an excellent question.
Okay.
But so the statute, and we had a very long discussion on this in the subcommittee with Senator Simmons and Senator Barnett, Senator Barrett, Senator Parker, who have done a great job serving on the subcommittee. Mr. Chairman, you put a great subcommittee together. I was proud to lead them on that. The crimes that are excluded are driving under the influence, murder and attempted murder, aggravated assault. I believe most of these, and you do have a copy of these. Looks like page 21, or no, page 9, 10, and 11 under the original bill. You'll see those actually delineated there. The concern that Senator Simmons had was if we're going to keep, if we're going to have a statute that outlines what are violent crimes, we should probably just start referencing the statute and leave it as that to keep you from doing that. As to your question about whether we're allowing for expungements of certain crimes that we're not ordinarily allowing expungements for, I don't know the exact answer to that. I don't know if Senator Simmons may know that. If violent crimes are able to be expunged or not, I don't believe they are under that statute. But the short answer to your question, without knowing what I know, as I just said, yes, this bill would allow for expungements of any crimes that allowed someone to be eligible for the mental health treatment court. If that crime is what led them to be placed in the mental health treatment court in the first place, if they meet all the requirements under the order that led them there, that crime would be expunged under this bill.
We could work together before it comes up on the floor to kind of compare and see if there are additional crimes.
I think that's a great idea, and I'd be willing to do that for sure. Absolutely.
I'll just, it works like drug court. If you go in, then it gets expunged and all that. It's like it never happened.
Mr. Chairman, if I may, it also is consistent with the language that's been proposed with our reentry courts. Just like the chairman just said, 9732 crimes, which is the section that deals with crimes of violence, from murder all the way down to shooting, drive-by
That's
shooting.
what's listed here.
It's listed as they are not eligible to enter into mental health court if it's one of those crimes. And that same language is the language that we have in our proposal this session for reentry courts. And it's the same language that currently exists for our intervention courts.
Okay, that answers my question. Thank you.
We should have recognized Senator Simmons to answer that question.
I tried to.
Like I said. Okay, we're on the bill. Do I have a motion?
I will move title sufficient do pass, strike all as amended. I think I fit that all in there.
All in favor, say aye.
Aye.
Opposed? All right, that passes. I'm gonna skip down to the House Bill 1351. That was tabled subject to fall. I'm gonna call that back up. This came over. It's a scripters errors, affidavits, and what you have before you. There's a proposed strike all. I'm not sorry, a proposed amendment. Oh, I don't have it. Okay, so what the amendment is simply doing is taking out lines 39 through 41 in subcommittee. There was some discussion with the Chantry Clerks Association, and they worked with the author and they agreed. The bottom line is lines 29 through 43 is dealing with what the affidavit or scriptures there means. Any questions on that?
I do have a question.
Okay.
That did come to the subcommittee. There was substantial discussion. The concern was putting a chancer's clerk in a position to have to determine whether it meets the criteria. That was the concern, because right now, a chancer's clerk, those public record individuals, they don't have any deference to not file a deed. They can file
understanding is that's been worked out by virtue of this amendment through the Chancery Clerks
It
Association.
appears it says, shall refuse to report any scrivener's affidavit not containing all information.
Deleting that, it's deleting.
Deleting that?
Yeah, that's.
Thank you, I'm sorry, I misunderstood your.
That, and I probably wasn't clear. That's my fault. So that's what that's what this amendment is doing, is taking that language out so that our chancery clerks are happy. That's what that amendment, and so to be, I guess, correct, we're on the amendment, and I would ask, so I'm calling, vote on the amendment. So that all in favor of the amendment, say aye. Aye. Okay, all opposed. Okay, that amendment carries. So my question would be, does that address the concern?
I believe we'll go. I would call upon my committee members also to consider that. I believe it aims to address the concern, and I'll have to look at it a little closer.
Well, I can tell you that, you got Trey here from the Chancery Clerks Association. So they worked with, at my request, and I explained what the subcommittee was going through. They worked with the bill's authors. So they are fine with that. Right. Video, okay. Questions on the bill as amended? All right, do I have a motion? Motion is title sufficient to pass. All in favor, say aye. Aye. Opposed? Okay, thank you. That one passes. I'm gonna go to House Bill 1099. This is, in short, what the strike all is doing is simply, I hesitate to bring the call up, but this is the real, this prevents name changes by offenders. If you recall, what we did in committee was stripped out all of Senator McMahon's bill except that part of it. There are chancery clerks who said that this has been an issue. And so what we've done is stripped out or put a strike all using our language that we passed and put a strike all into their bill. So the bill that we passed out of committee is what that is. Senator Clark. Yeah, if you look at this slides 29 through 30, the DOC chaplain doesn't apply with them. And I would assume they would carry that cover. On the proposed committee sub, items 29 through 30. Or if they do initiate it, then this law doesn't, then it can be changed. Well, this is the same bill that came before the committee, and it was stated that in a couple counties, this is an issue where vendors are continually filing these petitions, and this is an effort to minimize that. I do have any other questions?
A motion,
Motion.
title sufficient to pass strike all.
Motion is time sufficient to pass strike all in favor, say aye. Aye. All opposed? Ayes have it. Okay. Is there anybody here from CPS? DHS, thank you. All right, I'm calling up House Bill number 592. This is our last bill of the day. I'm asking if you will, and this also came through the task force. And it was a recommendation, and it came as a request from DHS. And the reason it's came was, this is a federal, I guess I would call it encouragement that we do this. And so if you will explain to the committee briefly, yeah. I'm bringing you to the floor to explain it. Senator Barry.
Thank you, Mr. Chairman. I do have a question, and how it relates to, the federal guidelines as to in Mississippi, 21 years old is seen as the age of majority. The federal guidelines recognize 18-year-old as the age of majority. I'm done. I was just curious.
Senator Blackman.
Thank you, Mr. Chairman. Now, the federal law is that after 100, if they're in for more than 180 days, that the child support is suspended. I mean, that's what they're requiring. And it's to resume 60 days after they're no longer incarcerated. And that's where I want to ask, is that required under what the state's saying? did not have a problem with somebody coming before their court every 4 months. That was the same.
I really hate that we are being forced to do this because we are giving a pass to individuals. And you did not bring this. I am not frustrated with you. I am frustrated that we are in the state that we say, by the way, we don't have any responsibility during this term. Tell me again what the House did. Explain this to me in the amendments that they placed in here. That as soon as they are through their incarceration period, that there is there a look back provision. What is that? Explain to me what you just said.
Yes, ma'am. The House has two amendments. The first is that this only applies to child support cases.
And tell me what those are. What are the child support cases that are within your purview?
They get assigned to anybody, so parents, assistants. Consider what I would say, what came out of the task force, correct me if I'm wrong, that is it 1% of the cases that y'all handle fall into this category? Yeah, yes, sir. So we're talking about 1% of the DHS cases, but we're talking about how many millions of dollars? The second half was, we have that seven, hearings. Thank you. I realize you have nothing to do with this. You were just presenting the information and I appreciate it. But again, Senator Simmons, you have a question?
Thank you, Mr. Chairman. I guess my question is a follow-up question raised by Senator Blackman and also that was just answered regarding those periods of time. Why are we treating this class of non-custodial parents different than any other class in the state?
Well,
As far as setting the time of
based on
reviewing
the
the
House
transfer.
amendments, you mean,
Yeah,
because the bill died over in the House, and as he stated, these amendments, and I'm telling you what Chairwoman Cockerham told me, it was rescued by these amendments. And what Senator Boyd's concern is what I understood to be the concern in the House. And if not for these amendments, then this bill would have died in the House. So that's the reason why they're treated differently than others.
I guess what I'm really concerned about is setting the time for review in Chancery Court. Like
Well,
my chancellor may want to review based upon the initial hearing in 6 months or a year because they got enough information in the initial hearing. But to specifically say to chancellors across the state, the
We
time.
certainly have a right to amend it as appropriate,
Okay.
but I'm just explaining to you, that's why that amendment is in the bill. And I'm telling you, that's why, based on what I talked with my counterpart in the House, that's
So
what
would,
happened.
so Mr. Chairman, would a reverse appeal be a friendly amendment?
Yes.
Okay.
Yes.
That'll be my amendment.
Yes. Senator England.
Thank you, Mr. Chairman. I also spoke with Chairwoman Cockerham, and I just wanted a clarification based on the fact that this bill died in the House and then was held on a motion, amendments were made, and it passed as amended. She had a concern that if we didn't do this, and I think this gets to what Senator Boyd was saying, that we hate being in this situation, but if we don't take this, these actions, there's a chance that DHS may lose a substantial amount of funding from the federal government. Is that correct? I think she said somewhere in the tune of 66% of current funding could be lost. Okay. And so I think that gets to what the chairman was saying, as well as what Senator Boyd was saying. I do have one other question for individual here from DHS. I appreciate you being here. I would echo what Chairman Wiggins said. If you want to present this on the floor, I think that would be a good idea. If an individual is found to, for whatever reasons, be collecting benefits under workers' compensation or disability or any other sorts of benefits that they're receiving, whether they should be or not, is DHS still able to collect or to garnish those benefits? Yes. And I think you're probably correct. I just, I may be misremembering if that's the word to use of a workers' comp claim where an individual was disabled through a workers' comp injury and was still collecting benefits. But thank you for at least entertaining that question.
Thank you, Mr. Chairman. I just want to be real clear on the actual amendment. I'm not trying at all to stop the state doing whatever it needs to do for the state plan. I understood the gentleman to say one explanation regarding the period of review in Chancery Court was not required by the feds. And this was just additional language from the House.
You were correct,
Okay.
but it's for the bill to have survived the House, that's what the amendment put in. Okay, that's the 4-month review is not a requirement by the feds, but it died straight up. And then, as he said, it was revived on a motion to reconsider, and Chairwoman Cockerham, and I'm not sure who brought forward the amendment, but they did it and it passed the House at that point. So I guess you could say it's a requirement of the House, but we can amend that too. So, okay, do we have an amendment? That's your amendment, okay? And the amendment,
Yes, sir.
okay?
I would presume that what you're trying to do is to be able to talk to the chancellor to see if they could provide some kind of guidance.
Okay, so we have before us the amendment. All in favor, say aye. All opposed? Okay, the amendment for reverse repealer carries. So now we're on the bill before us. We have a motion on the strike all. Yeah, I guess that's amended.
Title sufficient and due pass strike all is amended.
Motion's title sufficient, do pass. All in favor, say aye. All opposed? Okay. It carries. Before we have a motion to rise and report, I want to say that I think we will have one more meeting. We got a nomination. We have a nomination or two. We have some of that. So I wanted to say thank you to the subcommittees. I think it's been, me personally, this has been probably the best run committee since I've